Children's stories often involve invisible ink or vanishing text. It's usually the stuff of fantasy, but lawyers and litigants say it's reality when it comes to all-important court transcripts. And the implications are potentially catastrophic, with the outcome of cases relying on their accuracy. Is justice being erased?
As solicitors, we are basing our advice on these transcripts.
There has to be a better way to do this.
There are real concerns that the transcripts have been edited by judges.
If there are errors and omissions, then the whole system is threatened.
The ABC spoke to 9 legal practitioners for this story, but 4 declined to go on the record. Some saying they feared speaking out could lead to reprisals from judges in ongoing or subsequent court cases, or affect the outcome of current cases. Transcripts are one of the core foundations of Australia's family court system, especially in appeal cases, or when a party is alleging there's some kind of bias in the courtroom, coming from the judge or even one of the other lawyers. So errors can leave families and justice teetering on the edge.
There have been times when I've read transcripts of a case that I've run and I've looked at them, and what is in the transcript doesn't line up with what I recall and what my notes had said. I recall a case I ran some time ago where the judge had made comments which I thought would have supported an appeal. What I was looking for was just omitted, it wasn't there. It ultimately makes an impact on whether or not you proceed with an appeal.
The ABC cited transcripts that attributed dialogue to the wrong person, named the wrong legal practitioners, contained numerous typographical errors, and one transcript that was missing more than 2 hours of court proceedings.
If there's inaccuracies, if there are things that are left out of these transcripts, then how can our advice be relied upon? How can we give accurate advice to the litigants?
The Family Court told us court staff don't edit transcripts. That's the job of VIQ Solutions, the company contracted by the court to manage their audio and transcription files.
All equipment used to record hearings is owned and managed by VIQ Solutions, and no court staff member has access to the equipment, nor do staff members or judicial officers directly edit or alter transcripts.
But that's not what the contract between the court and VIQ Solutions revealed when it was released to the ABC under Freedom of Information laws. There are a number of reasons why a transcript can be edited, according to the previously secret documents. To correct typographical errors, to make the transcript more readable, to remove things of no substance to the case, to remove administrative matters, and to remove scandalous or objectionable remarks.
I recall times where a judge has said, look, I'll have that removed from the transcript if something scandalous has been said. And that should happen. But it's the controversial things where somebody is alleging something was or wasn't there or was slightly different. That's where access to the audio files would remove all of that controversy.
If the contents of a transcript are disputed, a request can be made to have it reviewed against the audio file, but that only happens in exceptional circumstances, according to the Family Court. Legal practitioners told the ABC it's so hard to have a transcript reviewed, they sometimes gave up.
The stress is huge and people pull out because of the stress, because they don't want to deal with it.
When you've ordered a transcript and you know what to expect in that transcript and you look at it and it's not there, you then have to think, well, I go around the process of reviewing this, getting access to the audio files. It's just a difficult process.
VIQ solutions are used around the world, including by the family courts in the UK, where similar concerns have been raised.
I had a case not so long ago where a client had said to me that she was sure that the transcript had been edited. They told me of specific words that the judge had used which showed a bias against this particular mother. And so we appealed that decision, and my client argued that she believed that the judge had edited the transcript, and the appeal judge said that that was a very grave allegation to make and there was no evidence to substantiate it. But the question is, how do you obtain that evidence? When I've asked them for audios, simply don't get a response, or it disappears into thin air, and it can take weeks, months and so on. And in one particular case it resulted in being told that the audio was no longer available.
Litigants and lawyers aren't just frustrated by the inaccuracies in transcripts, they're furious about how much they cost. A single day of proceedings can set a litigant back anywhere between $3,000 and $5,000. Other jurisdictions don't charge these kinds of exorbitant fees.
Well, the thing is, we've had one provider, essentially, that has a complete monopoly over this market. There's no competition that's been encouraged. There's no alternative solutions that have been pushed by the court. And really, it's in their hands to try and find alternative solutions that's more accessible to litigants.
The cost is scandalous. The cost of the transcript is often the first impediment someone has to reviewing what's gone on in their case.
The risk that erroneous and costly court transcripts could derail court cases has raised serious concerns about maintaining the integrity of the court. Anthony Wheely KC is a former New South Wales Appeals Court judge and currently chair of the Centre for Public Integrity. He says better oversight is needed.
I remember when I was a young barrister seeing in the local police courts occasionally that happened, where a local magistrate would simply say to the court reporter, "Don't record any of this," and then proceed to lambaste one of the parties or say something that was totally inappropriate. And that was many years ago. Well, you know, we hope that that doesn't happen anymore. But to see a modern day judge doing something of that kind, as I say, is an unpardonable offence and is deplorable.
These problems are why people have called for a federal judicial commission, a body that would oversee federal judges, a body that would address problems courts themselves don't seem able to.
We don't have one, and it defies description or any rational explanation as to why that should be so, because I seem to remember the Attorney General a number of years ago promised there would be one, and why isn't there one, I don't know.
Green Senator David Shoebridge agrees.
Of course we need a judicial commission. This is a reform the Greens have been supporting for many years now. We have the Australian Law Reform Commission saying it's essential that there be a Commonwealth Judicial Commission, and yet we get no action from the Albanese government.
The Attorney General's Department told the ABC the federal courts were responsible for their own operation and management.
It's not just a matter for the courts, and the Attorney General, as the first law officer, has the obligation to face up to problems if they are there and to help solve them with the cooperation of the courts.